Litigation finance agreements, an established part of civil litigation internationally, have been hardly utilized in New Zealand. However, this is changing. Just a while ago, the Supreme Court of New Zealand held that the courts have no role of regulating litigation financing. Accordingly, in the ordinary course, only the existence of such an agreement and location of the funder, but not the agreement itself, must be disclosed when proceedings are issued. The issue came about between New Zealand parties suing a U.S. company in relation to a failed insurance business. When Contractors Bonding US was informed by Waterhouses NZ of the existence of litigation financing, they applied for a stay of the proceedings on the grounds of abuse of process. Contractors Bonding based their argument on the rules against maintenance and champerty, which prohibits third-party meddling in litigation. However, the influence of these rules have declined over the centuries. Accordingly, the court held 4 key points, 3 of which that are not discussed in great detail. The court requires disclosure as soon as proceedings are issued of the identity of any financing arrangements. Finance agreements themselves may be required to be disclosed where this is relevant to an application for security for costs or third-party costs, or where a stay is sought on the grounds of abuse of process, provided a defendant is prepared to risk paying costs on an unsuccessful but credible stay application. They will still in many cases be able to compel disclosure of a funding agreement. In order to defeat an abuse of process argument, it will remain important to draft litigation financing agreements carefully in order to avoid effecting a bare assignment.